Let me get Aman Lekhi on this. Mr. Aman Lekhi, what are your thoughts on the process as it stands today and this confrontation with the government now?
Well, you see, either you call it babble, lacking restraint, sense, reason, or you see it as part of a structured discourse meant to diminish the Supreme Court and present it as essentially an obstructor. In either case, it's noise. In one case, it's pointless. In the other case, it's sinister. And in either case, it doesn't lead to meaningful debate. The question which you put was, should the government be involved? What is missed is that the government is already involved because the process is interactive. It's not as if the judges appoint judges, as is being simplistically put, because there is involvement of the government in the appointment. And in fact, that's where the problem comes in. Where does the problem come in? There has to be a memorandum of procedure. Now, the memorandum of procedure was first made in 1999 and subsequently, pursuant to the third judge's case, it was eventually finalized in 2017. The memorandum of procedure sets out the age, the eligibility, the complaint mechanisms, secretariat. So that sets out the process of appointment. The problem is that there is no meeting of the government on the memorandum of procedure. The court says that the memorandum of procedure is in place. The government disagrees because of some observation in Kandan's case. Nevertheless, insofar as the appointment is concerned, the IB is involved, the state governments are involved, the central government is involved. And the problem here is not merely appointment by the judges, but the stages in the appointment, that is, in the forwarding of the names to the Collegium in one case, or making appointments in terms of the Collegium's recommendation in the other case. What the law minister does not in any way flag is the conduct of the government in either of these cases, and he is egregiously wrong in saying that he is acting in terms of the Supreme Court order, because the Supreme Court order, the third judge's case struck the NGAC down. I mean, I have got my own reservation on the decision. Point is, that is a law. And that had a system of two nominees who are to be part of that particular committee, which is to appoint the judges. All that happened post that judgment was a decision, an order, requiring formulation of memorandum of procedure. Now, if the parties agree on the memorandum of procedure, the conditions relevant for the appointment would be as the memorandum of procedure stipulates, and that will bring in transparency as to the method of appointment.
But
it would have behoved the law minister to have actually...
Lekhi, what you said right at the beginning, that there seems to be, in a sense, what you're saying is that there is a sort of a structured way that an attempt is being made to diminish the Supreme Court. You use the word sinister. So are you saying that there is it's a sort of, I mean, you have the vice president who's been talking about this very openly, the law minister's, been in a confrontation with the judiciary. Are you saying that there is a sort of a larger plan at play here, which may eventually possibly result in the government pushing for a fresh law in Parliament on judicial appointments?
Well, the government is entitled to come with a fresh law. There is no bar in the government coming with the law. As far as the question as being sinister or not, that the question is moot. I see absolutely no reason for such comments. These comments are very frequent and have been made rather flippantly by responsible holders of constitutional posts. These are serious issues, have a long history, and have to be debated in a very serious manner. You cannot possibly play to the gallery while make comments and suggest that what you are saying is actually legally sanctioned when it is not. My problem is the way in which this particular debate is being structured. There is absolutely no issue in our reconsidering the method of appointment and devising a substitute to what exists. But you cannot, in the guise of substituting the system, attack those involved in it. And as far as judiciary is concerned, I feel it's a very important institution which deserves to be preserved and protected. And as far as judges are concerned, whatever may be the failing of the system, as far as judges are concerned, we need judges as they are for the purposes of upholding the values which we hold dear, so that our polity which is based on law remains protected. I am very against comments which become personal, which attack persons rather than deal with institutions or institutional issues.